supports. So about Jonathan Martinez, he is an attorney and the senior director for law and policy at the for the Burton Blatt Institute at Syracuse University. He leads its efforts to ensure that older adults and people with disabilities have access to the services and supports they need to lead independent and inclusive lives. In 2013, Jonathan represented Jenny Hatch. He'll be talking about that case tonight, so I won't go into it. The first trial, though, that held a person has the right to use supported decision-making to make her own life choices instead of being subjected to a permanent and plenary guardianship. Since that time, Jonathan has led supported decision-making projects in multiple states, including New York, Ohio, California, Virginia, Vermont, Missouri, and Kansas, and now Rhode Island. He has educated and trained tens of thousands of people around the country. I was fortunate enough years ago to hear Jonathan during one of his trainings and actually be able to talk to him about some issues that we had in our own family, wanting to avoid guardianship for my son. So it's a real pleasure, both personally and professionally, for Jonathan to be here tonight and to be working with him on this really great webinar series. He has written or co-written over 40 publications on supported decision-making, and I really recommend his publications. He's a fantastic writer and also a fantastic presenter, as you're about to see. So at this point, I turn it over to Jonathan Martinez.
Thank you so much, Morna, and there's no way I'm living up to that, but thank you for the billing. So it's a pleasure to be here, everyone. It's an honor to be here, and I'm very excited to talk to you about a subject that I think is the most important advance for civil rights for people with disabilities since the Americans with Disabilities Act. What we're going to be talking about today and in the rest of this series is supported decision-making. How supported decision-making can contribute to a better life for people with disabilities. And that is what we're going to be talking about. Today is what I call a why presentation. Today is going to be all about why supported decision-making is a good thing, why it can lead to a better life for people with disabilities, and why you should try it if you can. The rest of the presentations we do, the other 4 in this series, will all be about how we can use supported decision-making in the programs, in the supports, and in the services that people with disabilities use every day. So as I begin my slide deck, what I want to do is talk to you really quickly about a couple of promises I make in all of my presentations. Because if you have heard of supported decision-making, what you have heard about it is as an alternative to guardianship, something you can do instead of guardianship or to get out of a guardianship. And that is true. We are absolutely going to talk about that. But before I even begin, I always have 2 promises I make to every audience. The first promise goes like this. Even though supported decision-making is an alternative to guardianship, you're not going to hear me say today or ever that there should never be guardianships. I'm not here to tell you that if you're a guardian, you did something wrong, if you recommended guardianship, you were evil, or that guardianship should be abolished. That is not my point. My point today is to talk about options and to give you information so that if you ever have to make the choice, make the tough decision for a loved one about whether to seek guardianship, you'll have all the information, or at least more information, to help you make that decision. Second promise, everything I talk to you about today, every factual or legal statement I make, every assertion I make about supported decision-making is going to be backed up by one of 2 things: law, including the law in your state, and science, including 40+ years of studies. So the things we're talking about today are not vaporware. They're not aspirational. They're not hopes and dreams. The things that we're going to talk about today and in every webinar after this is based in hard science. Last thing, Morna said it, I want to repeat it. If you have questions, please feel free to put them in the chat box. I've asked Morna to monitor that and interrupt me if a good question comes in. If it's important enough for you to ask in the moment, it's probably important enough for us to talk about. If the worst thing that happens is I don't get through my slides, it means we've had a good conversation. So let's begin. The very first thing I want you to think about is something people don't often think about. I want you to think about your life and your rights. And think about the rights that make you the proudest to be an American, the ones that you hold the most dear, the ones that are so basic in your life, you don't really think about them because you know you have them. Things like freedom of speech, like freedom of elections, like freedom of religion, like the rights to life, liberty, and the pursuit of happiness. Now think about what they all have in common. Choice. Freedom of speech is the right to choose what to say. Freedom of elections is the right to choose who governs us. Freedom of religion is the right to choose how and when or whether we worship. Life, liberty, the pursuit of happiness is the right to choose the kind of life we live and with whom we live it. So choice is what makes our rights real. There's a quote up on your screen from a philosopher named Jean-Paul Sartre. If you've ever read Sartre, you know he's not the sunshiniest fellow, but he gets it right here. He says, I am my choices. Each and every one of us are the sum total of the choices we make. Every single day we make choices that shape us. The good ones, the bad ones, the silly ones, the significant ones. They make us who we are. So without choice, we don't really have rights, because if I can't choose what to say, what good is freedom of speech? So if you ask me what my favorite right is the right to make choices, the right to say what kind of life I'm going to have, to direct the kind of life I want. Now, clinically, that right to make choices is called self-determination. Self-determination is a fancy word. Really what it means is having control over your life, making choices in your life. People who are self-determined do things rather than having things done to them. They direct their lives. They control their lives rather than having someone else control their life. So when you hear self-determination, think making choices in your life to direct your life. And what we know from 40 years of studies, just some of them listed on your screen right now, is that for people with disabilities, particularly people with intellectual and developmental disabilities, those who have more self-determination, who make more choices, have better lives. We have study after study after study going back to the 1980s that find that when people with disabilities make more choices, when they have more self-determination, they are more likely to be healthy, independent, employed, happier, and safer. But the opposite is also true, because I want you to think about what your rights would be worth if you weren't allowed to use them. If someone said to you, sure, you got freedom of speech, but you can only talk when I tell you to, and you can only say what I let you say. That's not a right, is it? Or if I say, sure, you have the right to vote if I take you to the polls, and only then if you vote for who I tell you to, that's not a right either. So without choice, we don't actually have rights, because all of our rights come down to that self-determination and opportunity to make choices. But the scary thing is that's exactly what we have been doing to people with disabilities for about 1,500 years. See, here's a confession. I'm a giant legal geek. So I can tell you this because I've read what I'm about to tell you, is that about 1,500 years ago in the Roman Empire was the first time in the Western world that we put all the laws in one place. The Eastern world has us beat by thousands of years with the Code of Hammurabi. But in the Western world, the very first time they got all the laws together, all in one place and all in one book, was a book by the Emperor Justinian that he ordered to happen. And that book is called the Justinian Code. Second confession, I'm such a geek, I named one of my children Justin. So the Justinian Code, the first time we had laws and the first time we had rights in one place, one of the laws said that if you are feeble-minded, and that was their word for people with disabilities, you had to have a curator over you to make your decisions for you, to do things for you. So the first time we had rights, we had a way to take them away from people with disabilities. And that began what I call a culture or an expectation that if you are a person with disabilities, that is your destiny, that you're going to need someone to run your life, to take over your rights. And that has followed us for 1,500 years. In Great Britain, where we got most of our laws from, they updated the Justinian Code in the Middle Ages. They said if you are an idiot or a lunatic, and that was what they called people with disabilities, you had to have a committee over you to make decisions for you and exercise your rights. In America, we just call that guardianship or conservatorship, depending upon what state you're in. Now, I have to tell you again, there is nothing wrong with guardianship or conservatorship when it's done properly and when it's appropriate. And guardianship, when it's done appropriately, works the same way state to state. Every state has its own laws, and they have its own words and their own names. What you call guardianship in Rhode Island, they call conservatorship in California, for example. But even though the laws had different names, they basically work the same way, and they work like this. If a judge says that I can't exercise some or all of my rights, what that judge is supposed to do is take away the rights that I truly can't exercise, and only those rights, and give them to someone else, say in this case, Morna. In that situation, Morna becomes my guardian. She is empowered to do the things that I truly can't do. And again, if guardianship worked that way, I'd be a huge fan. The problem is what we know from study after study after study is that the vast majority of guardianships, over 90% in the largest study, take away all rights, whether or not the person is able to exercise them, whether or not the person wants to lose them, in some cases, whether or not the guardian wants the rights. Judges just say time and time again, it's easier to check all the boxes than to pick which one to check. And that's what I say is guardianship can be dangerous when it's taking away rights that people can actually exercise, when it's taking away opportunities that people should have. I call those types of guardianships overbroad or undue, because person doesn't need them, or they don't need them to be as broad as they are. And those types of overbroad and undue guardianships are dangerous because they give guardians often complete control over the lives of people. They let guardians say where you go, who you see, what you do, whether you work, what kind or whether you get medical care. And again, if that's what a person truly needs, there's no problem with that. But when a person is able to exercise their rights, that's dangerous when you take them away. Because we have known for almost 50 years from study after study after study that when people with disabilities lose their self-determination, when they lose their right to make choices, their lives get worse. We knew as far back as 1975 that when people with disabilities lost self-determination, they felt helpless, hopeless, and self-critical. The rest of that sentence on your screen is they would not, quote, behave because they saw no point in behaving. We know from another study that people who lost their self-determination had lower self-esteem. They were more passive. They were less likely to try new things. And that's not rocket science, is it? If I tell you time and time and time again that you can't do something, that you have failed at doing something, that you are not good enough or smart enough or strong enough to do something, are you feeling particularly motivated to try it? We actually even have a phrase for that. It's called learned helplessness, where we have had study after study that has found that if you take away the right to do something, people view that as a failure, a personal failure. And they're less likely to try new things because they think they might fail at those too. So what I tell people is guardianship is neither a good nor a bad thing. It is a big thing. And we have to think about it. Because if we do it without thinking about it, if we put it on someone who doesn't need it, we can actually make their lives worse instead of better. And that's a problem that Congress and the American public has known about for decades. I mean, there's been lots of talk about guardianship with Britney Spears. And about 3 weeks ago, Congress held hearings looking into guardianship. Well, Congress held hearings in 1987, almost 30 years ago, 35 years ago almost. Congress held hearings looking at guardianship. They took testimony from people under guardianship, from guardians. They looked at state guardianship laws. They did research. And what you're looking at on your screen right now is page 1, paragraph 1 from 1987. So this is things we've known about for 35 years. Look at the bold words. The typical ward, person under guardianship, has fewer rights than the typical convicted felon. When we put someone under guardianship, particularly overbroad and undue guardianships, what we're doing is we're giving someone ultimate power, the power to decide where they go, what they do, how they live, where they live, and whether they get medical treatment, and in the words of the congressman, sometimes when they die. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen. the rest of that sentence, except for the death penalty. So where can we go from here? I made you a promise. I'm going to keep it. I am not here to say there should never be guardianships. Of course, there are times when guardianship's appropriate. If a person is so disabled that he or she can't take part in the decision-making process, of course, guardianship's appropriate. If a person does not want to be part of the decision-making process and is putting themselves in danger, of course, a guardianship could be appropriate. In an emergency, if there's no one around to help, a guardianship, at least temporarily, can be very helpful. So again, I'm not here to say there should never be guardianships. But what I'm here to say is there should never be guardianships just because you have a disability, or because you're a certain number of years old, or because you need help, or because you're not particularly good at something, or the two at the bottom of the screen that really turn my stomach because I hear them all the time, because that's the way we've always done things, and because it's for your own good. And that one at the bottom really gets to me because, again, I hear it time and time again. The guardianship is for my son, my daughter, my mother, my brother, my sister's own good. Because without the guardianship, something bad could happen. And we say these things in the face of decades of studies that show it could be the worst thing for a person, the loss of self-determination. I mean, think about the term "for your own good." Think about the times in your life when you've heard that. Relax, it's for your own good. And ask yourself, have I ever heard that and then had something good happen? That is usually what happens right before you get a shot or a blood test. But that's what we say time and time again. I hear parents across the country say it, and they say it well-meaning. These are the vast majority of people seeking guardianship are trying to do the right thing. You know, I hear it all the time. If I don't get a guardianship, my son or my daughter or my loved one might sign something they shouldn't sign, or do something they shouldn't do, or meet someone they shouldn't meet, or go somewhere they shouldn't go. And they absolutely mean well. I never question, especially parents who mean well. But there's a great quote up on your screen. It's over 90 years old now, almost going on 95 years old, and it's still just as right as it was the day the Supreme Court said it. They said, when we mean the most well, we got to be the most careful. When we act without thinking, when we just assume something and don't think about the consequences, bad things happen. The greatest dangers to liberty lurk in the insidious encroachment by people of zeal who are well-meaning but without understanding. That means when we think we know what we're doing, but don't do the research. We think guardianship is the only option. We think it's the only thing that we can do. It's the best thing we can do. And we don't consider, again, decades of studies saying that self-determination is the key to a quality of life for people with disabilities, that losing self-determination leads to a worse life for people with disabilities. And yet I still hear it time and again. Might sign something they shouldn't sign, or go somewhere they shouldn't go, or meet someone they shouldn't meet. And I ask people, again, without judging them, to think about their own lives, think about things they've done. And I ask them these questions, and maybe you can play along with me and think about them in your head. Have you ever closed on a mortgage? And I have multiple times. I am like the mortgage crisis from the early 2000s in the flesh. So I can do a closing ceremony in my sleep. If you think about it, you're around a table, a bunch of people around the table with you. There's an attorney, there's a seller, there's the seller's agent. If you're lucky, you have an agent. But what is definitely in the room with you is a stack of papers going up to the ceiling. And those papers are handed to you one at a time, and you are told, sign here. Or there is a sticker on it that says, sign here. Well, ask yourself this question. Did you read those papers first? Because if you're like me, you didn't. If you're like me, you put hundreds of thousands of dollars and 30 years of your life in the hands of a bank. You didn't check out the fine print. You don't know if that bank is under indictment or not. That's a horrible decision. Where's your guardian? Or I ask them, have you ever consented to surgery? I have. I'm not only a legal geek, I'm a giant baby. So I remember my knee surgery really well. It was about 6 years ago. I get wheeled into the surgery center. My heart is going 1,000 miles an hour. I am basically praying for Valium. And there are people I have never met getting up in my face talking jargon. I'm your doctor, I'm your nurse, I'm your anesthesiologist, all talking medical jargon. But what they're all doing is shoving papers in my face and saying, sign them. And if you have been in that situation, ask yourself, did you read them first? Or like me, did you just sign them? Did you just put your lives in the hands of strangers and probably waive your right to sue? It's a horrible decision. Where's your guardian? We are, God willing, coming out of a couple of years of pandemic. But, we've all been stuck in our houses for a while. And I wonder if any of you have played my favorite pandemic game, or one of my favorite pandemic games, which goes like this. Have a bunch of drinks and go on Amazon and see what shows up the next day. With Prime, I can literally find out what kind of day I had by what shows up on my doorstep. If there's yet another piece of exercise equipment, I am not feeling very secure about what I ate. There's a pasta maker, I had the munchies. So these are all horrible things. We've all found ways to make horrible decisions in our lives. We have all signed things we shouldn't have signed. We have all bought things we shouldn't have bought. We have all done things we shouldn't have done. Doesn't that mean we need guardians for our own good, to stop us from wasting money, to stop us from signing things willy-nilly, to stop us from bad relationships? Oh yeah, bad relationships. I ask people the same question too. How many people out there have had a really bad relationship, but it taught you what a good one was? How many people out there have ever been that rescue buddy for someone, or had a rescue buddy? How many people have woken up in the morning and gone, oh, wow, I am never doing that again. I'm glad I did because it's a great story, but I'm never doing that again. We even have phrases for that: a learning experience or a teachable moment, for when we do the wrong thing but get better because of it. How many of us have ever made that mistake and grown from it, had that critical error that taught us what we want to be and how we want to be? Well, what I'm trying to get at is this. Jean-Paul Sartre was wrong. We're not our choices. We are our bad choices. We have all made horrible choices in our life. We have all signed things we shouldn't have signed, and done things we shouldn't have done, and bought things we shouldn't have bought, and dated people we shouldn't have dated, and had horrible experiences. You know what they've made us? Better, stronger, and smarter. We are better people for the mistakes we have made. So when people mean well, when people say that guardianship is for someone's own good, because I mean well and don't want my loved one to make that mistake, aren't we really saying, with the best of intentions, they shouldn't grow? They shouldn't have the opportunity to be the better, smarter, stronger adult, the productive adult and part of society that we earned with our pain? I have another example for you. Play along again. If you're old enough, think about the year 1995. The more I do presentations asking people to think about the year 1995, the more I realize that lots of people out there weren't born yet in 1995, or were in grade school in 1995. And as old as that makes me feel, I can say to all those people, on behalf of everyone else, we hate you. But everyone else, if you can remember 1995, think about it. Think about what life was like for people with disabilities in 1995. 1995 was only 5 years after the passage of the Americans with Disabilities Act. It was 4 years before the Olmstead decision said that people with disabilities have the full and equal right to be parts of their communities. In other words, in 1995, it was perfectly okay to say to a person with disabilities, you will live in an institution. You have no choice. I don't care what you want, what you can do. I don't care what your doctors say. You will live in that institution. 1995, a sheltered workshop where people with disabilities work only with other people with disabilities, making less than minimum wage, was not only legal, it was a preferred outcome. Schools and vocational rehabilitation could actually brag about the number of people they placed in sheltered workshops. In 1995, we didn't have Medicaid waivers like we have now. We didn't have programs like we have now. We didn't have supports and services like we have now. I want you to fast forward to today. It's only 26 years after 1995, but fast forward to today. Think about where we are today. Today, the right to be a full and equal member of your community, the right to live in the community, is a Supreme Court protected right. The right to work in the community, an integrated job, making regular pay, paying regular taxes, being part of the workforce, is an expectation. Someday, God willing, I will say it's a right. Today, we have waivers, we have supports, we have services, we have programs, we have technology. Consider the phones you have, the ones I hope you're not looking at because you're bored. Consider the phones you have and realize how much more these are than phones. In fact, we use our phones for things other than telephones way more than we use them as phones. My phone can help me have a call and a video conference with my doctor. It can also allow me to conference in someone else to be part of that conference so the doctor can understand me. So I can ask them to help me understand the doctor and ask the doctor to help work with that person to help the doctor understand me. With my phone, I can give someone access to my bank account to monitor my spending if I want, to watch me and help me budget. So if I am overspending, that person can go, whoa, Jonathan, you might want to cut back a little bit. With my phone, I can set reminders to take my medication. With my phone, I can set automatic refills for my medication. With my phone, I can set reminders for self-care and for appointments. Quick example, I have a client with a traumatic brain injury who also has diabetes. And because of her TBI, she sometimes forgets to look after her blood sugar. And a couple of times she actually had some pretty severe crashes. She was exactly the kind of person who would have been in an institution in 1995. But you know what she has now? She's got a free app that connects her glucose monitor to her phone. So if her blood sugar gets too low, it actually sends her a text and says, please eat something. If it gets lower, it texts her mother and her doctor and her sister so they can intervene. And just like that, with a free app, she's able to live independently. She's able to take care of herself, whereas she would have been in an institution just 26 years ago. That's the kind of world we have now. That's the kind of world we live in. We have more ways to make more people more independent than ever before. So ask me, ask yourself, ask anyone. Why have the number of people in guardianship tripled since 1995? In just the 26 years I was talking about, where people have gotten so many more tools to be more independent, the number of people who have gone into guardianship has gone from approximately 500,000 to, by some estimates, 1.5 million. That's 1 million more people in just 26 years. And statistically speaking, they have lost all of their rights. And before you tell me it's because we're getting older as a society, we are. The National Council on Disability released a study just 2 years ago, and they found that the fastest growing segment of the population going into guardianship are 18-year-olds with developmental disabilities. 18-year-olds who, statistically speaking, have lost all their rights for the rest of their life. At a time when we have more ways to make more people more independent, more people than ever are losing all of their rights because we mean well. And the science is scary. We know that people under overbroad and undue guardianships can suffer a significant negative impact on their physical and mental health. They do less well, they feel less well, they are less able to function. In some cases, they live less long. On the other hand, we know that people empowered to have more self-determination have demonstrably better quality of life. They're more likely to live independently and be part of their communities and work. And here's the number one reason why I hear from parents why they're seeking guardianship. And again, I never question parents for this. It's safety. If I don't get a guardianship, my son or my daughter might be unsafe. And the first job of every parent is to protect their children. I get it. I understand it. So I never question parents who say that. But I do talk about science. And there's a study on your screen that really captures it. There's a professor in New York named Ishita Kempka from Long Island University. And Dr. Kempka has spent a large part of her career looking at the interplay between self-determination and safety. And this is just one of the studies she did. What she did was she worked with a group of women with intellectual and developmental disabilities. If you don't know this, you should. Women with IDD are way more likely to be abused or neglected physically, sexually, emotionally than any other segment of the population. It's awful. So what Dr. Kempka did was she worked with a group of women with IDD. And I'm not a scientist, so what I call what she did was an apples to apples study, meaning she worked with women who had similar abilities and limitations. And what she did was a classic experiment. She divided them up. There was an experimental group and a control group. For the control group, she said, go live your life. For the experimental group, she gave them access to a curriculum that was designed to increase their self-determination, to help them make more decisions, to take more control of their lives, to expect more control over their lives. When the curriculum was done, she brought the two groups back together and she gave them a test. Again, a recognized test that was based on the ability to recognize potentially abusive situations and avoid them. You know what she found? Apples to apples, remember. The women who were more self-determined, who had gone through the course, were better able to recognize potential abuse and better able to avoid it. In other words, they were safer. And I have told judges this across the country. I've told parents this across the country. If you want to increase safety, don't take rights away. Build self-determination. And again, that's not rocket science. Aren't you more protective of the things you know are yours? If you know it's your life, your body, your moment, your stuff, your property, aren't you more likely to protect it? If you think someone else just has the right to take it away or the power to take it away, you're more likely to give it up. So that self-determination and that awareness leads commonsensically and scientifically to greater safety. And this is what I call the cherry on top of the sundae. There was a study done nationally called the National Core Indicator Study, and it was done in Rhode Island. It was done in almost every state, 46 states. And what the National Core Indicator Study did was it looked at the quality of life of people with intellectual and developmental disabilities. And like Dr. Kemke's study, it was an apples to apples study. It compared the quality of life of people with similar abilities and limitation to other people of similar abilities and limitations. They even used the old phrases, mild, moderate, and severe disabilities. So they compared people with mild disabilities, people with mild disabilities, moderate, moderate, severe, severe. And what the point of the National Indicator Study was to look at the impact on quality of life of people with disabilities of certain variables. One of the things they looked at was whether or not people had a guardian. And on that one thing alone, that one issue, having a guardian, what the National Core Indicator Study found was this: apples to apples, remember. People who do not have guardians are more likely to work, to live independently, to have friends, to go on dates and socialize in the community, and to practice the religion of their choice than people of similar abilities and limitations who have guardians. And that was such an amazing finding. They did it again a few years later. They again, on the same idea, looking at just the issue of having a guardian or not having a guardian, among the many variables, on that variable alone, though, they found the same thing. Apples to apples. People who do not have guardians are more likely to have their own homes, more likely to make choices about their lives, more likely to be involved in their community, more likely to be respected, to work, to socialize, to date, to be independent and get married. I ask people this: if we know, or at least strongly suspect, that the one thing standing in between having this and not having this could well be having a guardian, isn't 1,500 years of the expectation that people have to have guardians too much? Don't we need to stop and think about whether guardianship is appropriate before assuming that it is? So here's what it comes down to me. Where can we go from here? What I'm hoping I have shown you is that self-determination is the key to a good quality of life for people with disabilities. And I'm hoping I have shown you the other side of that losing self-determination can hurt the quality of life of people with disabilities. But if we can agree on that, there's one more thing we have to agree on. And that's this: self-determination is not just saying, go be on your own, go be self-determined, off you go, because of course not. Because people with disabilities often need more help. I mean, everyone needs more help. I spent a long time just trying to get into this webinar and going through the registration section. So help is part of life for everyone. So what I want to propose is this, and I hope you'll agree with me, that what we need to do is find ways to maximize the self-determination of people with disabilities, because that is the key to a better quality of life, while at the same time making sure that people have access to the help they need so that they can exercise their self-determination effectively and safely. And if we can all agree on that, and I hope we can, I have a story to tell you. And the story involves Jenny. And Jenny is on your screen right now. When I met Jenny, Jenny Hatch, her name is, I met her in 2013. At the time, Jenny was a 29-year-old woman. She was a high school graduate. For 5 years, Jenny had lived independently. And I don't mean in a group home, I mean in her own apartment. I saw the records, and the records indicated it was spotlessly kept with her roommate. Jenny had had the same job for 5 years, not a supported job, not a special job, not a sheltered workshop job, a regular job, making regular pay, paying regular taxes. Jenny was very politically active. She had a church she went to. She had friends she went to. She had a life she had. And in fact, that's the thing I want you to know about Jenny Hatch before, is that Jenny had a life like everyone else, and that's all she wanted. She wanted to go to work. She wanted to come home. She wanted to see her friends. She wanted to go to church. She wanted to live her life just like everyone else. And she did, until the day she was riding her bike and got hit by a car. An accident, by the way, that caused no change in her cognitive ability. It hurt her back. But Jenny had to go to the hospital and have surgery. And shortly after getting out of the hospital, she found herself on the receiving end of a petition for guardianship filed by her mother and her stepfather. So in August of 2012, Jenny walked into a courtroom in Newport News, Virginia, small town in Virginia, small courtroom in Virginia, with all her rights. She walked into that courtroom with all the rights everyone else has. And less than 3 hours later, she walked out with nothing. Jenny, who had been living in her own apartment and then later was living with friends where she was welcome to return to and wanted to live in, was instead put in guardianship and required by her guardian to live in a group home. I saw it. It was a nice place behind barbed wire where she didn't want to live. Jenny, who had a job where she wanted to go back to and was welcome to return to, was instead told that she had to work in the sheltered workshop operated by the people who ran her group home, where I saw her record. She worked more or less full-time for 8 months, made less than $1,000 total. Jenny's cell phone was taken away. Her Facebook password was changed. Her laptop was taken away. If you wanted to see or speak with Jenny, you had to fill out a permission slip, literally a permission slip that told the guardians who you were, why you wanted to talk to her, what you would talk about, where you would go if you wanted to visit her, how long you'd be gone, and when you'd be back. And you also had to agree on the back of the form to the rules of visitation. Rule number 1 was you're not allowed to talk to her about the guardianship, because the guardian said it upset her to talk about the guardianship. You know why it upset her? Because she didn't want to be in guardianship. She wanted to live where she had lived with her friends and was told, get used to your new life, you live here now. She wanted to work at her job where she was welcome to return and was told, get used to your new life, you work here now. She wanted to go to her church and was told, get used to your new life, we go to this other church. People always look at me like I'm making that up. So I actually put the permission slip online. You can see it. If you go to jennyhatchjusticeproject.org, there is a section on Jenny. It's a drop-down menu. There's a drop-down that says the Justice for Jenny trial. And you can see that permission slip, because I'll tell you why that's important. Because the first time I met Jenny, well, I guess I technically broke and entered because I wasn't filling out a permission slip, but I walked into the group home. Spoiler alert, if you carry a briefcase and talk fast, you can get in just about anywhere. I met with Jenny, and I was with her lawyer at the time. And I said, I'd like to be your lawyer. Can I help you? You know, I've heard about you. I've heard about your case. It sounds bad. I'd like to help you. Can I represent you? And she said, yes. So I became Jenny's lawyer. And first thing I did was contact the lawyer for the guardians, contact the lawyer for her parents. And I said, I'm going to be Jenny's lawyer. The case had gotten a lot of attention. It was on TV. I'd like to work this forward. I know you think she needs a guardian. She doesn't think she needs a guardian. That's why we're going to go to trial, and we'll set a trial. But I have a question, an important question. This permission slip doesn't apply to me, does it? And I was told, yes, it does. And I said, are you saying I'm not allowed to talk to my client about her case? And I was told, yes, those are the rules. Now stop and think for a second. If Jenny Hatch was, let's say, an axe murderer, and she was found holding an axe in one hand and holding a head in another hand, saying, I did it, ha, ha, ha. You know what she'd have a right to do? Talk to a lawyer. But Jenny Hatch wasn't lucky enough, I guess, to be an axe murderer. Jenny Hatch didn't have the same rights as an axe murderer because according to her guardian's attorney, Jenny Hatch wasn't allowed to talk to a lawyer. And so the very first time that I went to court for Jenny, I had to ask the judge to give her the same rights as an axe murderer. because I hadn't even been allowed to see her file yet. I hadn't been allowed to have more than one conversation with her yet. And again, go to jennyhatchjusticeproject.org. You'll actually see the motion I had to file that I attached the permission slip to, and the emails between me and the attorney saying I'm not allowed to talk to her. So we actually had to ask the judge for the right to talk to Jenny. Well, thank God the judge agreed. Because I was thinking the same thing you are. I know you're thinking it right now. Is why the hell does she need a guardian? If she was 29, if she was living independently and working independently, and the accident didn't cause any cognitive impairments, why would she need a guardian? So I thought the same thing, and I got to read the file. And the first thing I saw in the file was the order putting her in guardianship. I'm not going to bore you with all the language in it, but this, what you see on your screen, was like the last paragraph. This is what the powers the guardians had. Let's look at that. The guardians have the power to decide who sees Jenny, who visits her, what kind of support she gets, what kind of help she gets, what kind of safety and day services she gets, what kind of education and therapy she gets, and where she lives. Look at those words. Did Jenny Hatch have any rights left? When you lose all of these rights, are you really even an American anymore if you're an adult? Jenny Hatch lost everything in just 3 hours, mind you. Why? Well, I kept reading the file, and in the file was transcripts from that 3-hour hearing. And what I learned from reading the transcripts was this, that when Jenny was in the hospital after her back surgery, a psychologist went in to give what they call a capacity evaluation. A capacity evaluation is supposed to determine a person's ability to make decisions, a person's capacity to live independently. So this psychologist, who had never met Jenny, mind you, goes into the hospital, a place where Jenny had never been, mind you, and gives her a capacity evaluation while Jenny was on Percocet. Well, that psychologist was the star witness of that 3-hour hearing. And what you see on your screen in the bold are her exact words. When the psychologist was asked about Jenny's ability to live independently, the psychologist said, well, if she had assistance, she might be able to do that. When she was asked about Jenny's legal knowledge or ability to handle legal documents, she said she would need assistance to understand a legal document. When asked about money management, oh, she would need assistance with a bank account. When asked about what Jenny needs, the psychologist said Jenny's going to need assistance to make decisions. She will need people to guide her and give her assistance. When asked what would be best for Jenny, the psychologist said, I believe that would be beneficial to her is to be surrounded by people who support her and love her, who give her the assistance she needs. Okay, so I kept reading. And I learned that when Jenny turned 18, her parents had her sign a power of attorney. And by power of attorney, I mean one of the ones you pull offline that's like that big and has all the legal words in it that even I as a lawyer don't understand. So we asked a very simple question. If you think that Jenny isn't able to make decisions and isn't able to understand things, how did she sign a power of attorney? And frankly, we expected was for them to say that, well, we wanted to give her a chance, but now we know she really can't make decisions. But nope, they doubled down. Their exact words are on your screen. They said that Jenny was able to sign the power of attorney because her lawyer explained it to her. Her lawyer got to know her, let her ask questions. They had several visits and went over it page by page and line by line. And based upon the series of observations over several visits, the attorney concluded, and we concurred, that Jenny was capable of understanding these documents. At trial, they triple downed and say their doctor said Jenny was able to understand this complex legal document because it was explained to her. Well, at that point, I knew, and I know now, all these years later, that psychologist was actually right. Broken clocks, right? But that psychologist was right. I talked to Jenny pretty frequently. I talked to her almost every day during her trial, and I've talked to her minimum weekly since. And here's the thing. Psychologist was right. Jenny absolutely needs help to understand legal issues. She absolutely needs help to understand medical issues. She totally needs help to budget and manage money. And yep, she needs help day to day. You know what that makes her? Human. Aren't we all Jenny Hatch? There is no person listening to me right now, no person not listening to me right now that doesn't need help doing something. Everybody needs help doing something at some point in their life. The difference is is that if you are not a person with a disability, if you're temporarily able-bodied, as I put it, because we're all 1 second away from having disabilities, it's expected we're going to need help. We are supposed to give and get help. But people with disabilities like Jenny Hatch are expected to not be able to do anything. So what we had to show the judge was it's no sin to need help. It's no sin to, in the psychologist's words, need assistance. It's no sin to have people in your life who give you assistance. And what we talked about was supported decision-making. I know I'm 31 slides in and finally getting to the point. But supported decision-making was what we had to show the judge was what Jenny did and what's acceptable. So what's supported decision-making? Well, good news, there's a definition right up on your screen. You can screenshot this. I am sure that you can have this slide deck available to you. You can write this down. I can read it to you right now. Supported decision-making is a recognized alternative to guardianship through which people with disabilities use friends, family members, and professionals to help them understand the situations and choices they face so they may make their own decisions without the need for a guardian. That definition appears in textbooks and in articles. If you Google supported decision-making, you'll eventually find it. And yes, I wrote it. Now do me a favor, forget it. Because I think it's crap. I think it is pseudo-intellectual, insecure crap. If you really want to know what supported decision-making is, ask yourself how you make decisions. Ask yourself what you do when you don't know what to do. What do you do when the doctor speaks jargon? What do you do when the auto mechanic starts throwing around phrases you never heard before? What do you do when you need advice about a relationship? What do you do when you don't know what to do? You get help, don't you? You have people in your life who you go to for assistance. You ask for advice. You do research. So that's what supported decision-making is. Supported decision-making is getting the help to do the things you need to do to understand what you're going through so you can decide what to do. And we do it every single day. I guarantee you, you used supported decision-making at some point today. You didn't call it that because who calls it that? It's just life. I mean, think about all of the cliches we have in life about supported decision-making. Think about it. Don't go off half-cocked. Don't make a snap judgment. Make an informed choice. Get a second opinion. My dad's favorite phrase, if you measure twice, you only have to cut once. They all mean the same thing. Get help when you need it to do the things you need to do. Always double check. Always get advice. If you are in the workforce, you are often evaluated on your job, on how well you work with others and how well you seek help. Whenever someone comes to me for advice, first question I ask is, what research have you done and who else have you talked to? In other words, have you used supported decision-making? We are all using supported decision-making every single day. The difference is if you do not have disabilities, if you are temporarily able-bodied, using supported decision-making is a virtue. You are supposed to. You are called wise when you use supported decision-making. You are making an informed choice when you use supported decision-making. The difference, when someone like Jenny Hatch says, I don't get it, can you explain it to me? For 1,500 years of culture and history, we've just assumed she's dumb. We just assumed she can't do things. Because when people with disabilities historically have needed help doing something, society has assumed they can't do anything. And statistically speaking, through guardianship, they lose the right to do everything. So we had to show that judge that Jenny had been using supported decision-making quite well for her entire life. Again, she didn't call it that because who calls it that? But you saw the power of attorney. The lawyer explained it. Jenny understood it and signed it. There was a lot of talk about Jenny getting surgery after her accident. She needed back surgery. And we learned that Jenny is needle phobic and was originally not going to consent to surgery. So we heard from her father and her stepfather about how wonderful the doctor was. And the doctor saying, Jenny, it's one needle. And when we wake up, it'll be gone and you'll be able to walk better. And her family saying, Jenny, you got to do this, and explaining why it's important. And Jenny understood and she signed the consent herself. And that was a big deal to people, signing it herself. When her case manager testified, and her case manager was very pro-guardianship, we asked, how did Jenny sign her waiver plan? And we were told that they used person-centered planning. Don't get me started. But person-centered planning, where they went through her plan page by page and line by line, and they would not let her go to the next page until they were sure she had understood the last page, and she had to initial each page. And when she understood every page, and they were sure she did, she signed the plan herself. They talked about a Medicaid application. You ever seen one of those up to the ceiling? They explained it to her. She signed it. She understood it. Assigning a representative payee. They explained it. She signed it. She understood it. So for 6 days, I kid you not, we had witnesses on talking about the way Jenny used supported decision-making. We had experts on talking about why using supported decision-making was better for her independence, better for her quality of life. And we finally got down to what I am sure will shock you to hear is my favorite part of every trial, closing argument. Closing argument is when I get to live every Al Pacino fantasy that this boy from Long Island has ever had. So for about 45 minutes, I went around the courtroom pounding the table and saying she doesn't need a guardian. Because if she can make decisions without a guardian using supported decision-making, there is no need for a guardian. And after I was finished ranting and raving, the judge said, I'll be back in 15 minutes. He didn't come back for an hour. And that's good because it gave me time to tell Jenny we were going to lose. Because I was sure we were going to lose. The same transcript where we learned about the psychologist, the judge had been quoted as saying something like that he had a nephew with that affliction and would want him protected. The judge had questioned our experts about whether Jenny should earn her rights or should, start in guardianship and earn her way out. So I was telling Jenny, we're going to lose this case. And I'd expected to lose this case. We expected to appeal it and win it in the Court of Appeals in Virginia. And the judge came back, he started reading his order, and you can, again, see it on Jenny Hatt's Justice Project. And what you'll see is the first several pages were all about why she needs a guardian. Bad choices she had made, protection she needed. So it gave me time to rub her shoulder like you see on TV and tell her that we're going to fight this, that she had fought it for a year and she can fight it for more. And she said, and I'll never forget this, she said what she said every time we went to court. She said, he's going to send me home. And as she said that, the judge said, however, and you never saw heads come up so fast because no lawyer wants to hear however. You don't want to be on the other side of however. And what the judge said was, however, Jenny, you have not shown me that you are ready to be in charge of all areas of your life. So he did, in fact, keep her in a guardianship, but he said it was a guardianship over 2 things and 2 things only: health decisions and safety decisions. He gave her the right to make all other choices going forward. Okay, it was a start. Then the judge said it was only going to be a guardianship for 1 year, and that guardianship would expire in August of 2014 automatically, and it did. Jenny's been living without a guardian now for more than 7 years, going on 8 now that we're in October. Then the judge said one more thing. He said that the guardians are not going to be your parents. See, I didn't tell you about Jim and Kelly, Jim Talbert and Kelly Morris. Jim and Kelly were Jenny's employers. I told you Jenny had the same job for 5 years. She worked for Jim Talbert and Kelly Morris. And after Jenny had her surgery, she wasn't able to go back to her apartment. She needed specialized rehabilitation equipment. She wasn't able to live independently for a bit. And her parents wouldn't take her in. And I have no problem saying that. It's in the court record. Do you know who took her in? Jim and Kelly. Her employers said, come live with us. And Jenny did. And she wanted to live there and she loved living there. And they wanted her to live with her. They made themselves a family unit. So when Jenny was undergoing the guardianship procedure, before I'd ever heard the name Jenny Hatch, Jim and Kelly hired their own attorney. I think they spent at the end of the day about $50,000 on their own attorney. I mean, who does that? To fight for Jenny. What their position was that Jenny does not need a guardian. But if she has to have one, let it be us, because we'll support her. We'll do the things she wants to do instead of taking her rights away and making her live where she doesn't want to live. So the judge said that Mr. Talbot and Miss Morris would be the guardians for that 1 year. And then the judge said this, that the job of guardians is not to make decisions instead of Jenny, in Jenny's place. The job of the guardians is to assist people in making their own decisions, to help them learn to use supported decision-making. And that was the first time a trial judge ever used those words in the United States. He said, your job, guardians, for this 1 year is to prepare her to use supported decision-making. And there's 2 more things the judge said. He basically said, 1, get her out of that group home today, and 2, get her back to work if she wants to work on Monday. And Jenny Hatch, who walked into this tiny courtroom a year before with all her rights and walked out with nothing, got to walk out of that courtroom this way on that day. And this is my favorite picture that doesn't involve one of my children, because Jenny had been told to give up and get used to her new life, and she wouldn't. And look at that face. She never gave up. Learned helplessness never kicked in with her. So that's the front page of the Washington Post. It said Jenny got justice in the Justice for Jenny trial. She went home that day. And I have to tell you, it's a great story, isn't it? It is. It's a great, inspiring story. And if all it is a story, I just wasted your time. I just wasted about 20 minutes of your time telling it. And I don't want to waste your time, because this story can't just be about Jenny. When we say Jenny got justice, the important question is why? Why her? And the answer is not because she's an angel. The answer is not because she's a hero. The answer is not because she's quote unquote high functioning. Her measured IQ, and don't get me started on measured IQ, but her measured IQ was 49. So there are lots of people with higher IQs or higher functioning who no doubt have lost all their rights. So why did she get justice? Well, the reason she did is because she had help, tons of help. Friends and professionals, Jim and Kelly paying $50,000 for their own lawyer, professionals who knew her from around her community, who came and testified for her about the good work she did and why she should have her rights, the national organizations that came from all around to Newport News, Virginia, my now boss flying down from University of Syracuse to testify on her behalf for almost no money. The media loved her. Can you imagine why? There was a reporter who followed her case from day one, who brought it to people's attention. That's where the Justice for Jenny name came from. And she had a judge who was willing to listen and learn, who went from afflictions and earn your rights to supported decision-making. You know what that means? It means she got lucky. That's what that means, is she got lucky. And that's why I told you this story. That is why I told you this story, because the lesson that Jenny's story has to tell us all is this: our rights, our justice, our self-determination should never depend on getting lucky. They should never depend upon friends who have $50,000 to spend on an attorney for you. They should never depend upon you being telegenic. We should be born with rights. We are born with rights. And people with disabilities have the same rights as everyone else. That is the moral of Jenny's story, and that is why I told it to you. So where do we go from here? Well, this is your law on your screen. This is the law in Rhode Island. And the law says this: a person may not be put in guardianship unless a court finds by clear and convincing evidence, and that is the highest standard we have in civil law. You've heard of beyond a reasonable doubt. This is just below that. A person cannot go into guardianship unless there is clear and convincing evidence that that person needs a guardian to provide assistance with things they can't do. They have to prove that that person cannot do things, cannot make decisions in areas of their life, cannot make decisions in their life. Well, I want you to think about what that means, to be able to make decisions. That word capacity, again, the capacity evaluation that Jenny got. What I want you to think about is whether and what capacity means. Because you already know the answer to this question. You already know that capacity isn't a yes or no question. You know that capacity changes day after day. You know why I know you know this? Because your capacity is different than my capacity. There are some decisions that you can make without any help. There are some decisions you absolutely need help to make about things you don't know. There are some decisions that you can't make unless you have help. There are some days when you don't feel well enough to make any decisions. There are some times when you are so stressed out, you shouldn't be making decisions. You want the best example of this? Unless you have a medical license and a medical degree, you do not have the capacity to take care of your health, because you can't diagnose yourself and you can't prescribe medicine to yourself. But you know what you do? You go to the doctor. You get help. The doctor is the help that helps you exercise the capacity you have. When I go to the doctor, I'm a big baby, and I ask the doctor to make me feel better, and the doctor prescribes me a pill, I take that pill because the doctor said so. I don't read the label. I don't know what's in azithromycin or erythromycin. I don't know the difference. I just know that I trust this doctor to diagnose me and that the doctor recommended that I take it. So I have the capacity to take care of my health because I have the help from the doctor. So capacity is situation specific. It depends on the help you have. It depends on where you are and how you're feeling. So capacity changes day to day and situation to situation. So what you've got to think about when you're thinking about guardianship are two important questions. The first one goes like this. If you can only make decisions about your life, if you can only make financial and health and living and relationship and any other decisions about your life when you get help, do you need a guardian? And the answer to that has to be no, because otherwise you and everyone else who gets help every day would need a guardian. And the second question is even more important. Before you seek a guardianship, before you recommend a guardianship, you have to ask the most important question. What else have you tried? We cannot know. 98% of the time, yes, people in comas need guardians. Absolutely. There are some people who need guardians. But 98% of the time, I submit to you, you cannot know with clear and convincing evidence that a person cannot do things until you've given them a chance to try, until you've given them opportunities and support to see if they can, until you've examined other options. I tell this to judges all the time. I'd be happy to tell any judge in Rhode Island this exact thing. You can't get to clear and convincing evidence unless you think about what else has been tried. You simply cannot get there. There has to be evidence. There has to be questions about whether that person has had support or could do things with support. That's not my position, by the way, only. That is the position of the National Guardianship Association. The National Guardianship Association, which is made up of guardians, by guardians, and for guardians. Their website is guardianship.org. There is nobody more invested in guardianship than the NGA. And this is what they say. Before guardianship, try something else. Try supported decision-making. It might work. It might work. It might not. If it doesn't work, there's no problem with guardianship, because supported decision-making can do for people with disabilities what it does for you. Think about the way you use it in your life to get a second opinion, to weigh your options, to make that pro and con list, to make sure you understand what's going on, to interpret information in a way that you can wrestle it down to the brass tacks that lead you to make decisions. That's all what supported decision-making does for you. And it can do that for people with developmental and intellectual disabilities. Sure, they might need different kinds of help. They might need more help. They might need more intensive help. They might not, but they might. But the concept and the principles are the same. And here's the second thing you know, and it's good news. There's no one way to do it. So if you're out there thinking, get to the point, hippie, and tell me what I have to do. Tell me what step 1 is. Tell me what step 2 is. I'm not going to do that, because you already know that there's no one way to use supported decision-making. There's going to be someone someday, I think, that's going to try to sell you something and say, I have the one and only way, the one true book, the one true guide, the one true app that shows you how to do it. And when they tell that, run away. And I say that as someone who has written 2 books about supported decision-making. What I will never say is there's only one way to do it, because you already know the support you need is very different from the support everyone else needs. Some people just need... Yes.
Jonathan, this is Morna. I'm gonna. I hate to interrupt you. Gosh, this is an awesome presentation, but we have a really good question in the chat box, and I wanted to give it to you. This is from Vibhavi Gopal, and I really apologize if I'm mispronouncing your name. Her question is, how difficult is it to move from guardianship to supported decision making with all parties cooperating?
Theoretically, it shouldn't be hard at all. Because I think I'm going to show you this from your law, but every state, Rhode Island included, has a law that says if guardianship is no longer necessary, it can be terminated. I have absolutely represented people in just the past couple of months to help them go from guardianship to supported decision-making. The problem is often culture. The expectation that guardianship is still needed. You still have to convince that judge that it's the right thing to do. If everyone is on the same side, if there's no opposition to supported decision-making instead of guardianship, it should be easier. But I always tell people the easiest way out of a guardianship is not going in, because now you have to convince the judge that guardianship is no longer necessary. And where you run into culture is the old phrase for getting out of guardianship was called restoration to capacity. And I've heard judges say that's like being cured. And people with Down syndrome, people with intellectual disabilities, they don't get cured. So you run into that culture. How do you know you don't need it anymore? You needed it then. So my answer is, I hope it won't be hard because everyone's on the same side. But it might be. It comes down to the judge you get and the material you put forth. I hope I realize that wasn't a very inspiring answer, but it's the best one I have. I'd be happy to talk more with you about things like that, but that is the problem, is the culture of expectation that guardianship is forever. So that's the best I can tell you, and I hope it works better than that. But the thing that's important when you're developing those supported decision-making models is to think broadly, okay? When you are thinking about what the best way to use supported decision-making is think broadly, because everybody uses it differently. Some people might use informal support. I call it a listening ear or a shoulder to lean on, just someone to bounce ideas off of. Some people have what I call go-to people. I go to my sister, who's an educator, whenever one of my kids is having trouble in school. I go to a friend with questions about finance because he's in that field. I go to a particular attorney with questions that she's a specialist in. And we can write go-to people into agreements or into powers of attorney and advanced directives. We can say, I want to work with Morna on financial stuff. I want to work with Crystal Martin. I'm sorry, I see your name on my screen. I want to work with Kate Bowden about healthcare and Crystal Martin about financial issues because I trust them and they can help me. Some people even build what we call micro boards or circles of support, but kind of formal structures where I have almost a personal board of directors who I can meet with regularly, ask questions to, and get their advice about my life. Well, all of these things are supported decision-making, all of them, because they all do the same thing. They all involve me going to you for help, getting advice from you, getting assistance from you, so I can make decisions in my life. That's what supported decision-making is. It can take a million different forms. In fact, I always say there's only 3 rules of supported decision-making, 3 commandments, and they're all easy. We agree to these 3 things. We are all supported decision-making advocates. Number 1, we agree that everyone has the right to make choices to the maximum of their ability. And that's easy because that's the Declaration of Independence. We hold those truths to be self-evident. Number 2, I can ask you for help in exercising my rights, in help in making a decision, without you saying that must mean you can't do it, so you have to lose your right to do it. And that's easy because we ask for help every day and no one tries to take our rights away. And 3, we realize that there are as many ways to give and get help as there are people. You ever go to plan B? First thing you use might not work. The first way you try to empower someone might not work. Try something else. Try something else. Go to plan C, go to plan D. Sometimes we go to plan triple Q. Something might work. Nothing might work. If nothing works, guardianship's probably appropriate. But what's the rush? Given the rights at stake, what's the rush? Here's what we know from science. Remember how I told you that self-determination is the key to a better life for people with disabilities? Well, here's what we're finding out. That supported decision-making, people who use supported decision-making have higher levels of self-determination. And that's not rocket science. If I am using supported decision-making to make more of my own decisions instead of having someone make decisions for me, I have more control over my life. And what we know is life control, decision-making, self-determination is the key to a better life for people with disabilities. In fact, just this year, I published a study. In Virginia, we worked with 10 young adults with intellectual and developmental disabilities of all different levels of abilities. And what we did was we empowered them to use supported decision-making. We gave them options. We told them about SDM. We talked to their family. We talked to their supporters and said, go make a plan. Go make a plan that works for you. Some of them made charts. Some of them had a spreadsheet. Some of them just told me what it was. But they made a plan that worked for them. Then we followed them for a year. We asked them questions. We did interviews. We collected data. We talked to them. We talked to their supporters. We talked to their families. And here's what we found after a year. All of them that used supported decision-making, all of them were more independent, were more confident. They were better at making decisions, and they made better decisions according to the people in their life. And even in the middle of a pandemic, the majority said they had better qualities of life because they were doing it. So that's what the data is showing. And your law in Rhode Island already requires it. In fact, Rhode Island is one of the 13 states that actually has a law that specifically recognizes supported decision-making. Your law says flat out, the court cannot put a person in guardianship if there are less restrictive alternatives. And then the court comes right out and the law comes right out and says supported decision-making is a less restrictive alternative to guardianship. So Rhode Island has been in front of the curve, leading the way. Only 13 states and DC have these laws that say flat out supported decision-making is and should be an alternative. So how do we do it? There's no one way to do it, remember, but here's some guidelines if you want to try it with people. First thing you should think about is where the person wants help. It all starts and ends with the person. And we should be thinking about what life areas that person might want help in, where that person needs or recognizes the need for assistance. There's a great tool called the Missouri Stoplight tool. And I'm going to tell you about these tools. None of them are definitive. There's no one and only tool. This is one that might help you. The Missouri Stoplight tool is a guided interview. It's a question and answer session about typical life decisions. Working, taking care of yourself, taking medications, going to the doctor, arranging for transportation, managing relationships. And what it asks you is this something you feel you can do? Or how well do you feel you can do this? It's a stoplight tool because there's a red light, a yellow light, and a green light. Red light means I cannot do this at all, even with help. Yellow light means I can do this if I have help. Green light says I don't need any help. I can do this on my own. And if we do that with a person and do that with people in their life, we can collect enough data, I think, where we can identify areas where people want support, where people say, these are the parts of my life I want help in. And once you know where a person wants support, the next question is, how do you want to be supported? You know, there's about a 99% chance the person has used supported decision-making already. Hasn't called it that, but that person has gotten advice at some point in some way, in a way that worked. So have a conversation. What kind of support helps? What would work for you? Do you like things in writing? Do you like time to think? Do you want someone to explain it to you? What has worked for you before? And there's a resource called the Supported Decision-Making Brainstorming Guide that can help you have that conversation to try to think of ways that SDM can work for that person. So once you know where a person wants help and what kind of help a person wants, next question, who can help? Who are the people in your life? Who are the agencies in your life? Are there programs? And we're going to talk about all these programs in future presentations, like special education, vocational rehabilitation, Medicaid waivers, Centers for Independent Living. Who out there can help? Who are your friends? Who are your family members? Who are your professionals that can provide help? And once you have that, you make a plan. You do what I call coordinating support. One of my favorite resources, and it's not just because I helped write it, is called the Setting the Wheels in Motion Guide by a wonderful advocate in California. And Suzanne is a mom and an advocate and an educator. And Suzanne has 3 children with disabilities. And in the Setting the Wheels in Motion Guide, the first thing she talks about is her children and how she works to empower her children, how supported decision-making made a change in their lives. But the really cool part about the guide is it's got worksheets at the end. It's got worksheets that you can use to help you facilitate that conversation. Who can be in my life? Who is in my life? What kind of help is there? What are my options? Can we set up a schedule? Can we work together? How do we do it? Because once you have that, it's great to put it in writing. In fact, under Rhode Island law, you must have agreements to do supported decision-making. There's a form available in Rhode Island law. You can say, this is my supported decision-making. Just as easily, you can make a power of attorney. You can make an advance directive. You can create individualized education plans, individualized plans for employment, individualized service plans, plans for achieving self-sufficiency. All these plans you can include supported decision-making in. You can say, I want help here from this person in this way. That's all supported decision-making is. It's just common sense. We've all done it. It's just doing something we haven't done before. And I was asked before about getting out of guardianship. Well, in Rhode Island, if you are a guardian, your job is to make decisions in the best interests of the person under guardianship. Your job is to help that person develop or regain the ability to make decisions. In other words, you should be asking, what are you trying even after guardianship? What are you doing to empower the person? How can we empower this person? And we remember that using supported decision-making and having more self-determination is undeniably in people's best interest if you can make it work, because self-determination leads for study after study after study to a better life. So what we know under your law is if a person gets better at making decisions, if they pick up a skill, if they learn something they hadn't learned before, and it means that a guardianship isn't as necessary as it was, maybe in some areas of life, maybe in all areas of life. Your job as guardian is to go to the court and say, I want this guardianship to change. In fact, it is an obligation on the court. The court shall remove any guardianship if the person is able to make decisions. So to me, what that means is, as a guardian, your job is to use supported decision-making, just like the judge said in Jenny's case. Your job is to help that person learn to get better at making decisions, to learn to take care of him or herself, to build their self-determination. And if the person gets it, if they get to the point where they can make it happen, your job is to go to the court and say, good news, judge, I did my job, fire me. That is what we should be looking at as guardianship, a way station whenever possible, not a final destination. Because if we look at it that way, great things can happen. Jenny Hatch got to go home that day. Ryan King was right after Jenny Hatch. He had been in guardianship for 15 years. His parents never wanted to be his guardians. When they learned about supported decision-making, they did exactly what that person who asked the question did. They sought to end the guardianship for supported decision-making. That's him leaving the courthouse with his rights back. Tanya, who had had an accident and was in a coma, and her mother on her left did the right thing by getting guardianship while she was in the coma. While Tanya came out, they began clashing because she wanted her rights back and the mother wanted to protect her. They were fighting in court, spending money. The judge, the same judge from Ryan's case, called me in to say, can you help these folks? And I talked with them. Turned out they both wanted the same thing. They both wanted Tanya to be as independent as possible, but have help when she needed it. They left court that day after fighting for a year like that because they did a power of attorney with supported decision-making. Takora was living in her car because she had a guardian that was out of state and didn't get in touch with her, and she had no legal right to sign a lease. We walked out of court that day, guardianship over, with a supporter who was empowered to work with Takora to help her live her best life. And just about a month and a half ago, Marie Burgum in California at the end of a Zoom trial. I've never actually been in the same place at the same time with Marie, but I represented her for a year. And she, whose guardian was trying to force her to move from California to Ohio just because he wanted to move, and she didn't because she had her life and her job and her friends there. That's her with her supporter, her aunt, no longer having a guardian to control her life. So great things can happen and are happening. I told you, 13 states, including Rhode Island and Washington, D.C., now recognize supported decision-making, all since Jenny, by the way. It's only been since 2014, only 7 years since Jenny's case that people have been really talking about this, and we've got this incredible momentum. We can do great things across the country, and we can do great things if we start by respecting and protecting, by expecting rights. And if we do that, then everything else follows. Everything else I'm going to talk to you about in every other presentation is going to be all about how we can make this happen, how we can use supported decision-making in special education, in vocational rehabilitation, in healthcare, in money management, in life planning. And I can't wait to do it with you. It's been my pleasure to be here. That's my email on your screen. And I'm going to stay and answer any questions you want. But I also think if you have questions that you don't remember after the fact, email me. Reach out, because we have to have these conversations. If there's questions, if there's concerns, if you don't know what to do, we've got to connect with each other so we can figure out for the best. Thank you so much, and I'm happy to answer any questions.
Jonathan, thank you, thank you, thank you. That was just so informative and interesting and awesome. I'm going to start off a question from the chat while people get ready. If you want to ask a question, you want to unmute yourself and turn your video on, raise your hand, and we'll call on you so that you can,
I'll do it that way.
Okay.
Okay, I see Connie Souza's getting ready to ask a question. Jonathan, there's been a couple questions about forms, and I know in terms of conversations with folks in Rhode Island, and you mentioned that form that's in our statute, but for some reason, like there's a lot of, kind of thinking about what kind of form is best, and especially if you're an attorney working with somebody or somebody's working with their attorney, can you just comment a little bit on written forms and what people are using and how formalistic do we need to be about that and all that good stuff?
Well, in Rhode Island, your law says there has to be a writing that is not inconsistent with the form in your statute. So the advice I'm going to give is you got to do a form. I am not a huge forms guy. I think forms are good things. Models are good things. Your law requires it, so you should do it. I think it's protective. I think lots of people use supported decision-making, like we talked about, informally. But my advice is going to be, because your law is so clear, if you want to pursue this and want to do it, you should do a supported decision-making agreement, because my nightmare would be someone like Jenny defending herself by saying, I don't need a guardianship because I use supported decision-making, and having the lawyer on the other side say, no, you don't have a form. To me, that's a nightmare, because there's so many people who use it informally. But now it's something you can do to protect yourself, and also to show everyone else it's done. I don't know that society is ready to understand people with disabilities making their own decisions. Someday, I swear we're going to get there, where people are just looked at as people. But for now, the form is something you can give to doctors and lawyers and shopkeepers and teachers to say, yes, I'm making my decision, and my mom, my dad, my brother, my friend, or whoever is going to help me do it. Great. So my long, short answer is your law requires it, and it's a good idea to do it.
Great. And Connie Souza, you have your hand up. Do you want to just turn on your video and
I
don't have to.
I don't see where my video is.
Okay.
Sorry.
You should have a start video button toward the lower left, but if you don't see it, we can hear you.
I just have my mute button on the lower left.
Okay.
At any rate, Jonathan, thank you so much. I wondered if you could comment on supported decision-making in Canada. I know you practice in the US, but I think some things have gone on there too.
Yes, in fact, Canada's ahead. Some of the first supported decision-making laws were in Canada, in British Columbia. I don't pretend to be an expert in Canadian law, but some of the first studies and some of the first work and some of the first laws were in Canada. There are also supported decision-making laws and procedures in Australia, in places like Bulgaria. Ever since the CRPD, the Convention on Rights for People with Disabilities from the United Nations, a lot of countries have been implementing supported decision-making plans. I can't tell you what they all say, because that's not where I practice law, but I'm sure that they all have at their core the values that we discussed, that people have the right to make decisions and get help just like everyone else.
Great. Thank you.
Thank you. There's a chat just came up. Does DRRI have a copy of the form that Rhode Island requires? Morna, please feel free to share my slide deck with anyone who wants it. There's a slide that actually has the section of the law. You can just cut and paste that into Google and you'll find the form, or just Google Rhode Island supported decision-making form. I'll show you. I'm sure you'll find it. It's literally thanks,
Jonathan. We have the form on our website. In fact, I'll just ask one of our attorneys to put it in the chat box, but you can go to, oh, Liz Hubbard just put it right in there. So yeah, we've got that. We literally took it straight from the statute. I'm not sure we need to improve on that form, you know? So it is what it is. And they certainly took the time to put it into the statute. So
I couldn't agree more. If there's a form that you know is going to be legally recognized, you should start there.
right.
I'm a big fan of adding details. Your form has an area for like additional, what they call special instructions, but start with the form because you know the law recognizes it.
So I just want to recognize Carol Doros, who says, I'm energized to work with our son on supported decision-making and help him have the most self-determined life possible.
Best compliment you can give me. Thank you, ma'am.
And I see Michelle Machado from the Ocean State Center for Independent Living put her email into the chat box. Thanks, Michelle. Any other questions for Jonathan? Now's your chance.
My name is Heidi Shosted. Can you hear me?
I can.
Yes.
Hi, I just want to say you've been so inspiring. I wish there were more people like you. Speaking because I am a person who is my own guardian. I do not have supported decision-making forms, and I choose not to. I've been my own guardian for as far back as I can remember, and I choose to keep it that way. I have a couple of questions, and I have a fear. My fear is because I am my own guardian and happen to have disabilities, is it going to eventually be expected that they're going to try to force people with disabilities who do not use supported decision-making formally to use it formally?
Okay, so to begin with, first, thank you. But I have to disagree with you. There are lots of people like me, and there are several on this call. But I really appreciate you overestimating my worth. But there are plenty of people at Disability Rights Rhode Island who live and breathe and believe these issues. I'm just happy to talk about them. With your fear, my answer is two parts. One, I hope not. And two, I don't believe so. Because there's nothing in the law that requires supported decision-making. Supported decision-making isn't and can't be required. The law talks about it as an alternative. The law talks about it as an option. So in the same way that people can choose to seek guardianship, they can choose to use supported decision-making, or they can choose to live their lives. If I'm playing lawyer here, I always recommend that people protect themselves to the maximum extent possible to keep anyone from saying they should be in a guardianship. But I can't imagine a time when anyone says you are forced to have supported decision-making. It just doesn't work that way, and the law doesn't say it.
I have two more questions very, very quickly, and I promise they're quick. My two more questions are this. Have there been cases where somebody goes towards supported decision-making? Say, for instance, they want somebody to have a surgery or something like that, and the person does not want to have the surgery, and everybody in their network wants them to have the surgery. In those cases, have there been points where that has become an issue legally, situations like that?
Well, again, if you're asking if supporters can force you to do something you don't want to do, no, that's the point of supported decision-making. The supporters don't have final decision-making authority. However, if you're asking me if people have ever sought guardianship over someone because they don't like the decisions they're making, the answer is yes, pretty much every day. I mean, Jenny Hatch they sought guardianship because they thought she wasn't making good decisions. I was just involved in a case in Wyoming, literally a week ago, where the mom was seeking guardianship of a son because she said he needed help applying for Social Security and needed help with the doctor. Those were the reasons why they sought guardianship. They didn't like that he didn't listen to her with the doctor. So
Right.
yeah, if people don't like the decisions you're making, the law lets them seek guardianship. And there's always going to be a law that lets people seek guardianship, whether they get it, whether they're successful in getting it, or several other questions. But the answer to your specific question is supporters can't force you under supported decision-making to do something you don't want to do. Anybody can seek guardianship over you at any time, anywhere.
And I hope as part of your work, and I hope there are more and more people like you coming down the pike, but as part of your work, I hope that you also help to train people with disabilities to become the supportive decision types of people, and help people with disabilities empower and mentor others with disabilities that are living similar lives, because the peer-to-peer thing is very powerful.
Yep. In fact, I'm involved in what they call train the trainer projects in several states. Ultimately, this is about people with disabilities. It has to be about people with disabilities, and it should be pushed forward by people with disabilities. So anything I can do to help people take charge of their lives and help others do the same is the most basic form of what we should all be doing. And it's my hope that nothing about us without us isn't just a saying. It's actually the way we live.
Someday it will be.
Someday.
Jonathan, we have another question in the chat. Could you tell us, there's two questions. I'll start with this one. Could you tell us what kind of curriculum and supports are available to prepare people with IDD to improve their supported decision-making ability?
I think there's plenty of literature about using supported decision-making. There are still several studies going on. I'm part of a couple of them that are trying to develop best practices in doing supported decision-making. I would think because each person is different, you start with the person. You see where the person is in his or her life and what they're doing and what they want to do. I'd recommend starting with starting the Wheels in Motion guide and seeing if it speaks to you, seeing if the steps help you. Preparing to use supported decision-making is something I believe we do our entire lives. When we do the next presentation on special education, I'll be talking about exactly that, starting at age 3 to be ready to use supported decision-making when we need to use it.
Okay, great. And another question, who can seek guardianship other than families?
Anybody. The laws always say any interested person. Those are always the horror stories we see. There's a chilling documentary, I believe it was on Amazon, called The Guardians, about professional guardians in Nevada who would just file guardianship petitions over people they didn't know, take charge of their lives and their assets. So guardianship, if I can get on my soapbox for a second, I think the problem with guardianship, I always use the phrase culture, is that we've all been raised to believe it's just an okay thing. It's just what we do. And that every guardian has every best interest at stake. And even though every state, including Rhode Island, requires guardians to file reports saying what they're doing to help the person, I know that they don't always get read. Another case I had in Wyoming, we found out the guardian hadn't filed a report in 12 years. Court never picked up on it because we just expect that everyone has everyone's best interests at heart. And sometimes it just isn't true. So the answer to your question is anyone can seek guardianship over anyone else anytime.
Cautionary words. I don't see any other questions. Anyone want to raise your hand or type your question into the chat box? Comments? John Souza. John, you just have to unmute yourself.
Yeah, I just did. Thank you.
Great.
Thank you, Jonathan. I think you've really helped crystallize this stuff. I just have a kind of want to go back to a point that you made. and kind of get your sense of how families ought to kind of proceed now that they're learning about this stuff. And that is, how should people look to find people to become supported decision makers? Is it better for them to go to family first, or should they be looking for friends, associates, neighbors? Any experience out there in the field yet about who makes a better supported decision maker?
Still research being done, but I think by and large, the answer is cast a wide net, because just like in your life, if you're only hearing one voice, you're not getting a real breadth of opinion. So I always recommend that have at least a few people you trust that you can talk to. And that really comes down to what the person prefers. The person is building these trusting relationships. I have seen supporters be friends, family members, professionals, direct support professionals. I love when direct support professionals also provide support, because they see people in more places than anyone else. I think DSPs are the wave of the future for SDM. I've seen pastors be on support teams. It really is, each person has people in their lives that they trust. And part of the job of every family, whether it's a parent of a person with disabilities or not, is to expose your children to as many different experiences and possibilities as possible. I really like to preach, I know you've heard me preach, that this should be as natural a process as any other maturation process. We have experiences, we make mistakes, we meet people, people come into our lives, and we flow from there. I'm very wary of making supported decision-making into some kind of professional discipline. And by the way, it terrifies me. There are places that are going to try to get paid for it, that, you know, we have the one and only way, when I think people should be leading the way with what works well for them. I always start and I always end with the person and what he or she is comfortable with.
Yeah, just for information's sake, in Canada, in Vancouver, British Columbia, this organization called Plan Canada has been really promoting supported decision making after the Canadian law got passed, and because the Canadians are intentionally creating these support networks for individuals, and they've learned that it's a natural place to look for people to offer supported decision-making. In fact, I think the Canadians actually have an actual formal process that people can choose, to identify specific people from their networks to be those supporters, but not exclusionary. Anyone else can be added to it. But I know that that's been a very successful approach, and we here in Rhode Island, although we're not affiliated with the Canadians, we try to copy them as best we can without getting in trouble. And I'm really excited about the fact that more people are starting to want to go this route.
So
thank you.
So am I. I was doing some work with folks in Nebraska about an hour before this webinar. And what I told them is we are in a wonderful place right now, in that supported decision-making isn't a weird and new and scary concept. I told Nebraska, if you guys pass a law tomorrow, guess what? 14 jurisdictions beat you to it. So it's not like you have to break new ground. If we're not over the hump yet on public acceptance, we're damn close to the top of the hump. So it's a momentum issue. It's a common sense issue. And it's why I talk about the science so much. It is a scientific issue. To me, it becomes, why shouldn't we try this, far more than why should we try this? We know it has worked and can work. And if we know, like I said, the one thing standing in between having community integration and not having community integration may be having a guardian, why wouldn't we try supported decision-making first? It might work. And if it doesn't, guardianship's always there.
Okay, Jonathan, two questions. They're sort of, I think you could probably take them together. Will having a supported decision-making process in place prevent guardianship being applied by third parties? And are there any ways to monitor or reevaluate a supported decision-making plan put in place? From two
Answer
different.
the first question is having a supported decision-making plan or network does not in and of itself prevent someone from filing for guardianship. Remember the rule, anyone can seek guardianship over anyone at any time. What having a supported decision-making relationship will provide you with is a really good defense against guardianship. Remember that your law says that a person shall not be put into guardianship if they can use a less restrictive alternative. And remember that your law says that supported decision-making is a less restrictive alternative. So to me, it would be great to be able to say to a court, this person doesn't need a guardian because look at your law. This person's using supported decision-making. I imagine the other side could say, no, they're not. And here's evidence that it's all sham. But to me, it provides a very strong defense, especially if it's working well. As to the second question about reevaluating, I think we should always reevaluate supported decision-making. People come into and out of our lives every day. Things I need help with change every day. As I get older, I'm going to need more help doing things. As I learn to do more things, I may need less help with things. I may master more skills. So I've done powers of attorney with SDM in them in states that don't have supported decision-making agreements that specifically say, we will review this minimum every year. We will take a deep dive and see if it needs to be changed. You can, to me, it's almost like an IEP in special education. You can and should review it frequently and should change it when it needs to be changed.
Great. Another question. Are you aware of anything that's written for working with people whose primary language is not English?
There's some good material in Spanish on supporteddecisionmaking.org. And there is some good, I know that, because I did training with a Korean family support group for not just people from Korea, but Asians in general from multiple areas in Southeast Asia that has stuff translated into multiple languages. So I think it's worthwhile to do some Googling on that. California has some really good supported decision-making in multiple languages. I believe you can find that at disabilityrightscalifornia.org or ca.org.
Okay, any other questions? Hands up for asking questions.
This is Heidi Shosted again. I just had a comment. When you're reevaluating the supported decision making and what people need help with, it's also very important to reevaluate who is in the network. Sometimes people might start out with a really great person in their network, and then they have a falling out, or they don't get along, or somebody may try to abuse power. So it's always good to keep the supportive decision-making networks fluid, and that's something to keep in mind, that the people in them can always change as well and be taken out.
100% agree. We should be reviewing everything. Areas where we need help, methods of providing support, and who is going to provide it. We all have relationships that change every day. People come into and out of our lives. I did a supported decision-making plan that specifically allowed for that for a person who's coming out of guardianship in favor of supported decision-making. We laid out that this person is going to help me with this and that person with the other, but we also said this will be reviewed frequently. And as life situations change, so should the plan.
Great. There's no questions in the chat box at the moment. Anyone else? Okay. Well, you've gone well above and beyond the time that you promised us, Jonathan. So I really thank you for that and for such an inspiring presentation. I think I'm speaking for everyone, and the comments back me up that it's just been a fantastic session with you.
Thank you so much. And thank you everyone for coming. And as a quick commercial, we're going to have several more of these. This was why you should think about it. Next step is how to do it. And I can't wait to talk to you about it.
And along those lines, thank you. The next session will be November 16th, Tuesday, November 16th at 6 p.m. Everyone who's registered for this presentation will get an email for that, and you're automatically registered for those sessions. So, but we'll keep sending it around in case other people want to sign up, and make sure you let people know how much they can benefit from this, and what a great expert it is to have Jonathan here. And our next session will be on supported decision making and special education.
Thank you all so much. Good night.
Thanks, everybody. Thank you, Jonathan. Good night, everyone.